dealing with the kids who are sent for mental assessment. And everybody was asking, are these children mad? These were girls who were in school. Why should they be sent to Mathari hospital for mental assessment? Kwani ni mawazimu? Are they lunatics? Are they wagoroki? Have their heads gone bad? The judge in Embu said because of the common law practice in Commonwealth countries, mental assessment is part and parcel of the Kenyan law. If the medical assessment report comes that they are unfit to stand trial, the law says they will be committed to a mental assessment hospital. If these children will be found to be insane or unsound or one of them, what will the judge do? The judge will convict and commit them to what they call the power of mercy. The president can shorten. If you are given 50 years, the president can shorten to 10 years. Free, he can order for remission. And lastly, he can give a conditional or unconditional release from prison, subject to a committee called the Advisory Committee on the Power of Mercy. Welcome to Court Helicopter Explainer, where we are celebrating our mark of attaining 70,000 plus subscribers on YouTube. We are found on all social media platforms: Instagram, Twitter, Facebook, YouTube, all of them. If you are interested, continue watching us. We give you the best. 12 million views is not a joke. It is a good indicator that you are there. We are dealing with what happened with the Utumishi accused young girls at Kibera High Court. Two critical questions arose. One, the media was gagged. In the next episode, we'll provide the legal basis for excluding the media from covering the event. On this first one, we are dealing with the kids who are sent for mental assessment. And everybody was asking, are these children mad? These were girls who were in school. Why should they be sent to Mathari hospital for mental assessment? Kwani ni mawazimu? Are they lunatics? Are they wagoroki? Have their heads gone bad? The parents of those kids cannot understand that their children are mad. While the debate is that if you look at the CCTV footage, it might be true. These kids might have completely gone mad. And that is why they did what they did. All these are discussions on social media, are discussions in matatus. They are discussions all over. What really is the law? Do you know there's a section in the penal code and there are sections in the criminal procedure code that deal with these matters? Have these questions gone to court? Yes. We have two decisions from the High Court. In one decision, the court says it is not mandatory for one to undergo a mental assessment. In another High Court decision, we are told that it is mandatory to undergo a mental assessment. So this is where Parliament needs to put it. Are you aware there is no law that compels anybody to undergo a mental assessment before they take plea? That is established. But what is the practice? The practice almost globally, is that before you take a plea on a capital matter, especially murder, everybody is entitled to undergo a mental assessment. This is the debate that we want to bring to you, and this debate, we hope the Speaker of the National Assembly and the parliamentarians will take it that we need a law to provide directions and parameters on how either one is supposed to undergo a mental assessment, or two is not supposed to undergo a mental assessment, free, whether it is discretional. Can one opt and say, me, I don't want to do a mental assessment, and what are the repercussions in that matter? And lastly, the rules must be provided for how it must be conducted. Is it conducted alone? Is that person falling under a mental health question? What are the constitutional provisions? Let us start with the most interesting decision, where a court found out that it is not mandatory, it is discretional to undergo a mental assessment. This is the case of, this was a matter in the criminal case of E077 of 2029. Justice Grace Nzioka, judge, delivered a ruling in November 1st, 2021 in the case of Republic versus Mzuya Ngolo Lewis. Yours truly, Danstan Omari, was acting in this matter. And the question that was there is that the applicant was a police officer. He was charged with the offense of murder. Let me read it so that everybody understands it. Brief facts. The accused was charged with the offense of murder contrary to section 203 as read together with section 204 of the penal code. The accused could not take plea because the information that is in the High Court, it's not called a charge sheet, it is called information, could not be read to him as the mental assessment report was not available. The prosecution sought time to obtain a mental assessment. The defense, led by Danstan Omari, was objected to this adjournment on the matter on the ground that the Criminal Procedure Code did not require that a mental assessment report be availed before the information or the judge was read to an accused person. What did the judge find? The judge found out that, according to Justice Nzioka, he said, it follows that when a person is accused of committing the offense of murder, the society presumes that the suspect was out of his mind to commit an otherwise heinous act and would require scientific proof to the contrary. This is because loss of life is permanent and is irreplaceable. It cannot be compensated by an amount of damages. Paragraph 48. Be that as it is, I find that in the absence of express provisions of the law, the judge finds there is no express provision of the law. The choice as to whether an accused person will be subjected to a compulsory mental assessment before plea lies with the accused person. It cannot therefore be held that that violates one's constitutional rights when it is discretionary. There is no legal bar to the accused person who wishes to undertake the examination. This court, the judge found out that it is discretionary. There is no law compelling that. In the second authority, that is the authority of Justice Kavesa, that's where the children, those 8 accused persons, were taken. This is a case of Republic versus Sarah Wairimu Kamodho in the top Cohen's matter. This is the judgment. This is a ruling of January 29th, 2025. In this matter, Sarah Cohen had already taken a mental assessment before the prosecution terminated her case. Later, the DPP, exercising his rights under Article 157, ordered that the file be opened and Sarah Wairimu Kamodo be charged afresh. So she was charged, and before she was charged, the defense argued that that she cannot be again forced to do another assessment because she had already done a first one. The prosecution argued that there is nothing, there is no prejudice involved in that matter. She can undergo another mental assessment. What did the judge give in her ruling? The judge said in paragraph 27, the application by the prosecution to subject the accused person to a mental assessment before taking plea is hereby declined. The judge said the earlier one stands. Number 2, a copy of the mental assessment report filed in Nairobi HCCRC number 60 of 2019 shall be submitted to this court and shall form part of the court record. The judge said the earlier report that had been done in 2019 is sufficient. So you cannot compel somebody to do several tests of mental assessment. In the third case, we have criminal case number E011 of 2022. This is in the High Court, Embu. Lady Justice L.M. Njuguna judge in November 5th, 2023. Republic versus Joseph Musyoka Nsuki. The judge in Embu said because of the common law practice in Commonwealth countries, mental assessment is part and parcel of the Kenyan law. What will be the import? And in the event the court finds out that they are unfit to take trial, what is the import of that matter? If the medical assessment report comes that they are unfit to stand trial, the law says they will be committed to a mental assessment hospital. So let nobody think that if the mental assessment report says that they will not take plea and they will not proceed. The position of the law is that they will not take plea, but they will be still retained in a mental hospital. This is what happened with the matter of the multimedia issue, where the accused person Mutinda, the first time the report came negative, he was not fit to stand trial, the court detained that person. The second time an assessment was done, it came out that he is now fit to stand trial. Then he took plea, and from that time, the case is going on. So it is not only that those 8 girls will be acquitted because their mental assessment is not true. Then the next question is, if the report comes out that at the time they committed the offense, they were insane, they had mental challenges. At the time they committed the offense, what happens? This is what faced the judge in Garissa. This is criminal case number E003 of 2023. Justice John Onyego J. in March 13, 2025. The Republic versus AAI. What are the brief facts of this matter? In paragraph 3, PW1, Siad Hamsi Hassa, a senior clinic officer, testified that on this date, the deceased was presented at the facility having suffered serious injuries. Paragraph 2. So, somebody was murdered, and the court looked at this issue. In paragraph 28, The court says the last element that of malice aforethought. It is incumbent upon the prosecution to prove that the accused assaulted the deceased and that he had malice aforethought. In the instant case, the prosecution circumstantial evidence pointed at the accused person as having killed the deceased, but with a rider that he suffered from a mental illness at the time of question. They produced a mental assessment report of the accused person prior to him being charged, and the same was to the effect that he was not fit to stand trial. Accused was then committed to Mathari Mental Hospital, where he underwent treatment until he was certified fit to stand trial. So this is a case similar to this 8 girls. If the mental assessment finds out that they are unfit to stand trial, that report will be kept in court. They will be remanded to Mathari Mental Health Hospital. The judge says if it is true that this person has a mental illness, then he's not a prisoner. He becomes a patient. If these children will be found to be insane or unsound or one of them, what will the judge do? The judge will convict and commit them to what they call the power of mercy under Article 133 of the Constitution of Kenya. What does Article 133 of the Constitution of Kenya say? Article 133(1). On the petition of any person, the President may exercise a power of mercy in accordance with the advice of the advisory committee established under Clause 2, 1, by granting a free or conditional pardon to a person convicted of an offence. 2, postponing the carrying out of a punishment either for a specified or indefinite period. C, substituting a less severe form of punishment. D, remitting all or part of the punishment. So the president has 4 options. He can say if you're sentenced to death, he remits it to life imprisonment. 2, the president can shorten. If you are given 50 years, the president can shorten to 10 years. 3, he can order for remission. And lastly, he can give a conditional or unconditional release from prison, subject to a committee called the Advisory Committee on the Power of Mercy. The Advisory Commission of the Power of Mercy is where these people will apply. You will apply directly to there. Originally, such people used to be detained at the pleasure of the president. Before the coming into force of the Constitution 2010, previously people were being detained at the pleasure of the president. From 27th of August 2010, Article 133 came in. The president has no power. People are not detained under the president's pleasure. They are detained and they will make an application through the power of mercy, the advisory committee, who will sieve and look at whatever it is. And it is not only those ones found under mental health. Anybody in Kenya who is in prison can apply. And the president, you always see Jamhuri Day on the 12th of December every year. Very many prisoners are being released. They apply through this position. Wakili Danstan Omari, bringing it to you as it is. But as we said, we wish justice for the 8 girls. We wish justice for those 16 girls who perished, and we pass our condolences to the parents who lost the kids and the families that who have their children still in hospital. Wakili Danstan Omari.